if you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond.
It's your boy Oouchie, Oouchie Court Watch, where we break down the whole hearing and the law behind every move. Today, Judge Raquel West out of Beaumont, Texas. 3 defendants, 3 different roads. 1 signs for prison, 1 gambles on a jury, and 1 man is carrying a loss no bond can fix. This one's heavy, but stay with me. Let's get into it.
Mr. Whitmire, in cause number 25, DCCR 0057, you're charged with the second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance.
First up, Mr. Whitmire. Second-degree felony possession, pleading guilty freely and voluntarily, every box checked. West runs the whole script. You competent? You understand? You sure? Boom. 3 years, Texas Department of Corrections, and she dismisses the companion case. No speech, no fireworks. Real talk. Sometimes court ain't a movie. It's just paperwork with a prison sentence stapled to the back.
You can go back with the bailiff.
Thank you.
See, and so am I going to have to start? And this is cause number 25, DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385, charged with assault of a public servant. And what is the announcement?
Yes, she wants to trial. I've conveyed it.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
Right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? Yes. And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible.
Now, Mr. Harmon's a different animal. Aggravated assault with a deadly weapon plus assault on a public servant. The state's dangling 15 years concurrent. But here's what he better hear. With his record, West says the range is habitual, 25 to 99 or life. So do the math. 15 ain't the punishment, family. 15 is the parachute.
Well, because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you could turn around and try the next one as well.
Yes, Judge. We'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. That makes sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial. Then you can go back with the bailiff.
And he turns the parachute down. Wants a trial, wants time to hire his own lawyer. Respect the fight. But peep what West just explained. 2 different offense dates means if a jury hits him on both, she can stack them. Consecutive back to back. And that's her call, not the jury's. So concurrent was the gift. Roll the dice and at the same time can flip to one after the other. That's a man gambling with decades. Somebody in his corner better run the numbers.
Good morning. Are you Joseph Roberts?
Yes, ma'am. Good one.
Good morning. This is 20-34226. Mr. Roberts, looks like you were on probation for the felony offense of driving while intoxicated, and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment.
Now the one that stays with you. Mr. Joseph Roberts, already on probation for a felony DWI, a 7-year sentence probated and hanging over his head. Then a new DWI allegation drops, plus a curfew slip and no ignition interlock. Right now, no bond. He's sitting, and his lawyer, Mr. Nix, stands up to ask Judge West for a lifeline.
At Level Up Treatment, Texas, that you went to April 26th through May 29th of this year. Mr. Robert, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a SCRAM device, comply with any curfew set by the court. As the court can see, he did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake. And if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we made the court.
And give the man his due. 3 days after that arrest, he checked himself into a full month of inpatient rehab. Voluntarily. Nobody forced him. In a system where most folks wait to be ordered into treatment, he ran toward it. That ain't nothing. That's a man who looked in the mirror before a judge ever made him.
Aware with the district attorney, his daughter was brutally murdered about 10 days ago now, somewhere around there. 2 weeks. About 2 weeks ago. Her daughter's his daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any.
And then the reason this hearing hits so different. Mr. Roberts' daughter was killed, a homicide, out of a domestic violence situation. Her funeral is this Saturday. There's no bid here, no clever take. A father is asking a judge for the chance to go bury his child. Rest in peace to her. Strength to that family. Let that breathe for a second.
Any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling, therapy for alcohol, substance abuse. As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have two homes, one home that they live in, another home that they haven't been able to sell. So they have two mortgages to pay for and bills. Is that correct, Mr.
Yes, sir.
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it or where is it? What's it through?
It's Trust Health.
Trust.
Trust. TROST.
Trust.
Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on?
That's a group.
Is it online?
I do it virtual. I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
On top of that grief, this man's the main provider. 2 mortgages, a family leaning on him, a real job out at Bechtel, and he's already signed into an outpatient program. 3-hour sessions, 3 days a week, random screens, therapy for the drinking. He's not asking to walk free and party. He's asking to keep working, keep healing, and go say goodbye. But watch, West is compassionate, not naive.
The court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that it's.
It's not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see. Do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor. I can pull it back up.
Ours didn't, because it's an older case. It's not in here. Okay, please, ma'am. I guess an issue that I have that we're going to have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already have been there, done that.
Here's where West earns the role. She digs in the file and finds it. Back in March, Robert signed a no driving agreement with probation in writing and the new DWI about 5 weeks later. So when the pitch is, trust me, I won't drive, West basically goes, homie, you already put that in writing once and here we are. That's not cold. That's a judge reading the fine print you hoped she'd skip.
How many set of keys do you own?
Man.
No, to your
No,
car.
I have one, my wife has one.
For the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
And she doesn't just talk, she moves. How many sets of keys? Turn over both. Wife's got the spare? That comes in too. See, anybody can say they won't drive. West is out here deleting the option. That's the difference between hoping and handling. You want the bond? The car keys are the toll.
I have previous PSI.
Sounds like it's coming as well over here. Thank you, Mr. Nichols.
You take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court, with the driving. I believe a SCRAM will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay. Okay, so Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there will be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail, and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case, and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond.
Then the plot twist. The state agrees. Prosecutor says a SCRAM alcohol monitor covers the substance worry, and given everything this man's walking through, they're not opposed to a reasonable bond. And West sets it up straight. This is make it or break it. One slip, and you're looking at the 7 years you already agreed to. When the prosecution and the defense nod at the same time, you know the human being outweighed the paperwork.
Understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a SCRAM device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever, period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that, sent to your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay.
Yes, ma'am.
So that'll be a condition of bond as well as your probation.
So West rules $25,000 bond. But read the conditions, cause this is the master class. A SCRAM device around the clock. One positive test. There's a warrant. No bond. Hello, 7 years. Never drive again. Period. Any circumstance, you and the homies drinking, you walk, you Uber, you do anything but touch a wheel, and keep that treatment going. Proof to probation every week. She didn't grant freedom. She granted a tightrope with a net made of consequences.
Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right. So what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done, because being in prison won't help the rest of your family. Okay. All right.
Thank you, Judge.
Yes, sir. I'll shoot a message over to
Thank
Judge
you. I
Townsend.
appreciate it.
And she lands it human. Being in prison won't help the rest of your family. That right there is the whole hearing in one line. Accountability and mercy. Same breath. He tells her, thank you, twice. Nobody knows what tomorrow holds for Mr. Roberts, but he walked out with a chance to bury his daughter, hold his treatment, and keep his family standing. What he does with it, that part's on him now. That's the tightrope, y'all. A judge holding a man fully accountable and handing him a lifeline at the exact same time. If real backbone with real heart is the content you rock with, tap subscribe and ring the bell on Oouchie Court Watch. Drop a candle in the comments for that family and share this with somebody who swears the system's got no soul. Your boy Oouchie out.